what America was and what it can become. This is Liberty Town Hall.
And thank you for joining us here today on Liberty Town Hall. We have the pleasure of having Ken Thompson and Tom Dunn here to talk about personal property rights and our land rights. And in order to get everybody on the same page so we can all understand where we're at going forward, we're going to flash back to an interview that we had done previously, and so that everybody can be on the same page. So stay with us as we talk about what personal property rights you have or don't have. This is about land and our liberties. Who wants to take a crack at trying to sum it up in the easiest shot? You want to give it a shot, Tom?
Well, I think it's important that you start at the beginning, and we don't have enough time to start way back with the king and the royal land grants and so on and so forth that started the 13 colonies, the original 13. But I think it's important that we understand that from that original 13 colonies, we here in Michigan, were seeded out of Virginia. That's where the Northwest Ordinance came from.
So the whole Northwest Ordinance come down to the Virginia colony.
That's where it started out.
Right.
And when Virginia and the other 13 colonies decided to merge, then the Northwest Territory, which was their territory, was ceded to the federal government.
Okay, so now the federal government owns it all.
The federal government had control.
Control or ownership?
Ownership,
okay.
Control
all right.
of that, because it was given to them by Virginia. So now you have the Northwest Ordinance, which is a document that outlines what's supposed to happen in that area after Virginia and the 13 colonies started ceding land to the federal government. That's quick.
So there's
a
set of rules
it.
Spelled out on how they had to do this, though.
Absolutely.
Okay.
Absolutely, and you can look that up under
Are we
the
following
Northwest
those rules
Ordinance.
today?
It's still in place.
It's still
there.
in place.
It's still in place.
And so the title on our individual properties, our deeds, they fall underneath the same rules.
No, they date it back to the Northwest Ordinance. Northwest Ordinance was a statutory authority within federal territory, which the Northwest territories were, on how they would be organized and subdivided down to the township level, which is 36 square miles.
So when I go get title insurance on my property to get my mortgage or whatever,
well,
and
we're
they
getting
run this back, it goes all the way back to there?
Yeah, but we're getting a little ahead of ourselves.
Okay.
I mean, we just jumped a whole bunch.
Okay.
But what we want to do is back up and
years.
get a little bit of history
okay.
on why this is happening, Glenn, and where this all comes into when land and liberty, our property, is supposed to be ours, and why the forefathers wanted it. So I'll jump back in that we had the Northwest Ordinance. And in 1835, the state of Michigan wrote our Constitution.
The state Constitution comes into play,
the state Constitution. Yes. But we could not have our Constitution approved by the Congress because we did not have an outline. We didn't have Michigan. It was all because Ohio and Michigan were having a bit of a problem, and it was called the Frostbite Convention or the Toledo Strip.
Okay, so that's where the Frostbite Convention comes in, and that's where we picked up the UP in exchange for that strip down in Ohio?
Absolutely correct.
Okay.
So in 1837, once that happened, what happened at the Frostbite Convention?
In September of 1836, Michiganders were a little upset with the current state government sitting in Detroit. And the legislature in June and July refused to accept the conditions of statehood, which was to cede the Toledo Strip and accept the Upper Peninsula. So they
wanted to keep the strip, forget the UP.
Yeah, they wanted the mouth of the Maumee River, Toledo.
Well,
and they actually went to a day.
Nice deal, though.
Yeah, it is. It turned out to be. So what Michiganders did is they stood up and, using the strength of the unratified state constitution, basically politically overthrew the state legislature and held a convention in Ann Arbor on December 14th and 15th of 1836.
Okay.
And it was after an election process was held in September. The conventioners met in Ann Arbor, and they accepted the law of Congress to cede the Strip.
So at this point now, the authority is at the legislators now. That's what this basically settles down.
Right.
And then it falls underneath the Michigan Constitution now.
Correct.
Okay.
And with the Frostbite Convention, the delegates came together and says, yes, we'll cede the Toledo Strip, sent the paperwork to D.C., and it was ratified by the Congress on January 26 of 1837. And one of the interesting conversations was John C. Calhoun denounced the Frostbite Convention. He said it was just horrible that Michiganders would stand up and overthrow the state government sitting in Detroit.
Horrible.
Horrible, just horrible that people would stand up and take control and show the limits government has. And this is what's the heritage of Michigan, which is unfortunately not shared on a daily basis with folks. For government never wants to let anybody know that they are a limited form. And the Frostbite Convention, which established our state on equal footing with the original 13, was the result of Michiganders standing up and doing what's right by the rule of law, not by the will of men.
So how does this compare to other states' constitutions? I mean, is Michigan the worst one of the bunch or the best one of the bunch? Where we rank as far as constitutionality back to our liberties here in Michigan?
I think the Michigan Constitution is probably one of the best models. I may not agree with some of the things that are going on today, but the root of the Constitution of 1835 is amended in 1850, it is amended in 1908, and it's amended again in 1963, has a very strong empowerment to us, the citizens. And just as an example, if you go read the Floridian state constitution, that constitution empowers the dicta of a court. And in fact, it's written in the Florida state constitution that the citizens of Florida are dependent upon rulings of the Supreme Court, which goes back to the Tallman in the 2000 election.
Well, this is going to be interesting. In our next segment, we're going to talk about, what part do you guys want to bring up next? Because I got a list here, and I want to make sure you're right here. How property was ceded, right? I want to make sure I get this right, because if we jump out of sequence, we're not going to be able to get the punch at the end of all this, right?
Right.
If you stay with us, we'll be right back and talk about how land was ceded here in Michigan. And welcome back to Liberty Town Hall. We're joined here with Ken and Tom discussing land property rights. We left off and Tom was going to talk about the public lands ceding, correct?
That's correct. Tom? Yeah, property was ceded once Michigan became a state. The property then that was not already committed within the boundaries or within the exterior boundaries of the state of Michigan, now that we have the UP, was ceded to the federal government.
What do you mean by ceded?
They gave it to them as part of our Equal Footing Act. All the original 13 colonies each had a certain amount of land that they gave to them, and they said any land that we have now becomes the federal government's for them to take care of and get rid of as they need to do. So
really, I don't know where the Constitution says the federal government owns land except 10 square miles for Washington, D.C.
It becomes federal territory, because within the Constitution it gives the federal Congress the right to control lands within the jurisdiction of the United States, which would be the federal territories. The seat of government was the 10 square miles, but there was post camps and stations in the acquisition of property, such as the secession of the original 13, which created the underpinnings of our state in Ohio.
Okay, because I was really questioning how we're actually doing some of these land grabs at the federal government level for. They make all sorts of excuses, protected zones and...
Well, that jumps up to my favorite progressive president, the accidental presidency of Theodore Roosevelt, and the monument, the Antiquities Act in 1906, falls right in line with what you're discussing.
Okay, and so it's different than ceding.
Correct.
It's two separate issues.
Correct. And
that's what I wanted to get to.
And the growth of that act, just as a sidelight and a commentary, is the admittance of Nevada in 1864 during the Civil War by Abraham Lincoln and his maneuver of that state, because when it joined the Union, to this date, 85% of Nevada is still in the hands of the federal government.
Interesting.
And we'll be talking about a court case that's rather interesting in that too, because when these lands within the public land state, Michigan, and other states as well, we're just talking about Michigan now because we live here, we're Michiganders.
Right, but this applies to all the states, correct?
It applies to the states, public land states and public lands,
okay.
Absolutely. So when we as a state let the federal government have control over all those lands that weren't already spoken for, okay? and we can go into this in
So
depth.
part of the state was
meeting.
occupied and people had settled it already.
Correct.
And then there's this vast open area that's been untouched, so they just said, feds, you can take care of it.
You take care of it, and you can sell it to help pay some of the debt, but they couldn't sell it until such time as it was surveyed. All right, it had to be surveyed, and that's where we have our township reigns and sections,
yep.
that it was surveyed so that they knew
And everything
what
in,
somebody
everything
was
in this
getting.
state's been surveyed, right?
Yes.
So we've
Everything's
complied
been
with all that. Okay,
Correct.
keep going.
So now when that land was surveyed, then the federal government would issue a patent, which is, if you
Not a
wanted to look
deed.
at, not a
patent.
deed, the patent on the land.
Goes to the state or the individual now?
Individual.
The individual gets a patent from the federal government for this land?
Yeah, for the purchase of the land from the public domain to private holdings.
And for $1.25
Right.
an acre. Some of it was given away. Some of it was given back to the state of Michigan, such as the Swamplands Act, and we're not talking about the DEQ and the wetlands. We're talking about swamplands. It was given back to the state, and the federal government, the Congress, wrote specific laws that said to the state of Michigan that you have this land and you can give it or sell it to an individual if they will drain it and make it productive.
Wait a minute, hold on.
Whoop, just a minute, you got a question.
Time out. We're supposed to drain these swamplands.
Yes.
I bet the Eco Green Party is just going nuts over this concept.
It's what the federal
That's what they were supposed to
government-
do.
That's what they were supposed to do in order to get the patent to the property.
Okay, so
To
if they didn't drain
get
it,
their
then what?
deed, to get their deed, their paramount deed to the property, they had to drain it. If they didn't follow the mandate and the state came out and looked at the property and said, look, your property's not drained, you don't get it, so get off, because they still own the property.
Yeah, it's basically homesteading.
Yeah.
So it's a homesteading with a rule that
Gotta
says you have
drain
to
it.
make the land usable.
Yeah, improve it.
Improve it.
Correct.
And if they didn't improve
They've
it,
changed that rule, by the way. Apparently, I'm missing it because that's not the procedure today. So again, I guess we're going to have to wait to the punchline of all this.
well, when a regular patent was issued, and we've had people say, well, you know, this patent, this happens to be a certified, this happens to be the patent for Ken's property down in Ionia County.
An actual patent.
Yeah.
from
This
the
is
federal
it.
government.
This is it, from the
original
federal
patent.
government.
We'll make this available on the internet for everybody, and up on the show, we'll give this full screen. But you actually have a patent from the federal government saying you own the land now.
No, I have the patent from the original purchaser of the land. I have the lineage of the history of the land.
Okay.
The original purchaser was 1837 by name of Mr. Woods.
Okay.
And down through the ages, the lineage, it was sold and divided and sold and divided. So I can trace my lineage, my standing, back to the original patent for the continuity of ownership.
And what good does that do us?
It is
Other than,
I'm sorry.
other than you're going to get a title check, okay. I mean, your title insurance, fine, if you can go all the way back, but what good does that do us?
Don't even want to talk about title insurance right now, but what I want to talk about is what the federal government said. And in Ken's case for his, it says, to have and to hold the same together with all rights, privileges, immunities, and appurtenances whatsoever nature, hereunto belonging to the said Joseph Wood, to his heirs and assigns forever. Now,
So it's saying it's your land, bottom line, it's nobody else's, it's yours now. That's clear title by
Correct.
definition,
Clear
correct?
title.
it's
by
called
definition.
paramount title.
Correct.
This
Okay.
this is the title to which Ken owns his property. And
Well,
there
we're gonna
are
have to
no
get into-
rules and regulations that can stand in front of that, just based on the contract between the federal government and Mr. Thompson.
And we're going to get into that when we return with more Liberty Town Hall after this message. And welcome back to Liberty Town Hall. We're joined with Ken and Tom talking about our personal land and how that evolves from the founding of this country and who owns my land? How do I, what? You're talking deeds versus patents and whatnot and lineage that goes back hundreds of years. title searches only go back 50 years, so how do I know if I own my land?
Well, a title search or title insurance, as you said earlier, is only for marketable title. So a warranty deed, a quitclaim deed, a sheriff's deed is under color of law, and you can look that up in Black's Law Dictionary. We won't go into that right now. But if you don't have the lineage, then what can happen is that the grandson or the great-great-grandson can step in and claim that property because he can show lineage from the beginning all the way to his part, where you only have title insurance under color of law.
So how do we go back and find out who actually has all this? How do we make sense out of this?
Have you ever heard of an abstract?
Yes.
In the
Abstract
old,
deed, yep.
In the old days, when Mom and Pop bought a piece of property, before a deed would issue or a warranty deed would issue, or any kind of deed, or a bill of sale, which you don't hear of very much of anymore, but a bill of sale is absolutely wonderful if you can use it, because then it's not a statutory word of art. So you get the abstract or the lineage from day one back to the patent, and you follow that all the way through to today, then you own it.
And we have to do it ourselves, or would we hire a title company to do this, or what's the best way to do it?
The best way to do it is either do it yourself, or you can have somebody do it. But if you know what you have and what you found, then you have a stake in what is happening, and you know what's happening, so that you can show that if you are ever accosted on your property, that you can show where they are wrong. Am I not correct here, Ken?
Correct. How you substantiate your standing on the property is understanding the systemic scheme, which is statutory law. The state has a right to finance. Finance is done by taxation. Taxation is a double-edged sword. Taxation is a point of control and a point of funding. Unfortunately, for the past 100-odd years, since the Antiquities Act of 1906, they're using taxation as control in lieu of funding. And the system they've established in Michigan over the past 100 years, and just using 1906 as a start date, you need to start from somewhere, is that they've usurped our rights to our property by using statutory law under the color of that authority. And they're able to do this through the subtlety of the law. And this subtlety is, to the end extreme, a sheriff's sale, when you fail to pay your fee, i.e. your land tax. But when we joined the Union on January 26 of 1837, we stood on equal footing. And when you read the federal Constitution, if I remember right, Article 2, Section 3, Article 1, Section 2, I got to check my notes.
Article 4.
No, we got to start with Article 1.
Okay.
Section 2, direct taxation.
Yes.
The federal legislature is the only authority that has direct taxation. The state surrendered that.
So
the state has no authority to send anybody a tax bill on their private property. The state has an absolute authority to send a tax bill to creatures that it charters.
wait a minute, hold on. Time out, back up. You're telling me that by law, people in Michigan don't have to pay property tax?
No. I'm saying by constitutional limitations, the state does not have the authority to wrap their funding schemes around our private domain.
Well, our schools and everything is funded locally here by our property tax.
The property tax is one scheme they use to fund the schools, and it's one of their carrots they hold out in front of people to wrap around it, but we're funding a public school. If you go back and read the Northwest Ordinance, which established the territory here in Michigan, they would fund the school by the sale of the lands. The sale of the lands, not taxing the lands. They would sell the lands within the township to fund the school and the school marm, use the old phraseology.
Every Section 16 within every township.
Yeah, we had School Section Lake when I was growing up. They had a lake or a little park,
16.
And we raised money for our schools with School Section Lake. Yeah, absolutely.
Was,
I remember that growing up. So
yeah,
it was a long time ago.
The school section, the Section 16, was allotted to the schools for education.
Yep. And so that was the recurring money to fund them ongoing, and we would use the land sale to initially build them or get them up and running.
To fund them.
And then we'd use the Section 16 to have the ongoing revenue.
Yeah, the revenue came out of Section 16, and they subverted that, slowly but surely. You know, you put the frog in the boiling pan of water and turn the flame up slowly, and you keep the frog, and he doesn't wake up. The problem here is that we don't understand our own rights. We're not provided the learning platform for our own rights. We are misled deliberately through the sleight hand of education, especially public education. This is the whole realm we're dealing with. We're dealing with public rights, and I emphasize the state does have a right to taxation, but it does not have a right to use that taxation to stand where it doesn't belong, and they don't belong in our front or backyard. Now, if you go to the state and ask for a privilege, such as you want a charter, you want to be a local banking company, you want to be a local merchant under state charter, then at that point the land you're sitting on falls within the criteria of a public service business, Article 9, Section 5 of the state constitution, 1963. It says very plainly.
We're going to have to wrap up for today. Can I get you guys to come back and finish this conversation?
We certainly will.
So we will.
Thank you very much. And thank you for joining us today on Liberty Town Hall. As we step back in time and we brought everyone back up to speed on what property rights are all about. And next time on Liberty Town Hall with Ken and Tom, we're going to get into the details and what you can do about it, how your property can be protected. So make sure you follow us here on Liberty Town Hall as we stand up for liberty all across this country.
I pray heaven to bestow the best of blessing on this house, and all that shall hereafter inhabit it. May none but honest and wise men ever rule under this roof. Letter to Abigail Adams, John Adams, November 2nd, 1800.